Hi everyone, it's Dean Hutchison here. We're going to get started in a couple minutes. Just want to get the room as full as possible. There's already 200 of you so in there. We have a wonderful lineup, but I'll be back to start it fully in about 2 minutes. Anyone who comes late or who has to leave early, don't worry, it's being recorded. It has to upload completely the link and then it gets automatically emailed out to everyone who's registered. So if you have to scoot before it's done, don't worry, you'll get the whole meeting once it's over. But we'll be back live in about 2 minutes. Thanks. Okay, so we're going to get going so that we can try and get to everyone's questions and everyone's comments as we go. I just want to start briefly by thanking all the panelists that are here. We have an amazing group. This came together very quick. We have, just so you know, we have Allison Wilson, who's a psychologist out of Denver who works in the fertility field with parents and families, and she's going to speak a little bit about working and counseling with parents and surrogates during these times. We have Rich Vaughn, who is the former chair of the ABA Art Committee. He's also attorney at IFLG, who's going to speak about kind of the legal issues we're seeing. We have Dr. E. Feinberg from Northwestern Fertility and Reproductive Medicine, also the president of, this is, of course, I don't have it on my hand, the president of the Society for Reproductive Endocrinology and Infertility, who's going to speak a little bit about the current ASRM guidelines that came out, as well as just the IVF process too. We have Sarah Page from Art Risk, who's going to talk briefly about the insurance aspects that are going on. We have Steve Snyder from IARC, from Steve Snyder Law Firm, also former chair of the American Bar Association's Art Committee, who's going to talk about combination of the legal aspects and the agency perspective. We have Dr. Danishman from San Diego Fertility Center, who's going to talk about the IVF process. We have Jennifer White from Colorado Surrogacy and Seeds, again, who can touch on the agency aspects as well as potentially if there's military-based questions. We have Wendy Wilson from Gifted Journeys and Seeds, same thing, talk about the agency perspective and other questions. And we have May at Circle Surrogacy, as well as the current chair of the American Bar Association's Art Committee, who's just hopefully going to moderate, but happy to jump in on questions. I apologize in advance. All you're going to get is this boring white screen the whole time. It was thrown together by myself, who didn't go to business school, who so doesn't have a huge PowerPoint repertoire. But if we do some in the future, we will have more slides, et cetera, if necessary. There's no video either, it's just voice. I can assure you that despite all the stress and anxiety everyone's going through and living and working at home, everyone looks amazing tonight. You just don't get to see them live on the screen. Just so you know, before we get going, I'm going to introduce everyone again so they can kind of go through their background and give their opening speech. But if you have questions, there is a box on the right side, a question box. You can start to fill them up immediately. If a question, it's better just let everyone go through their first opening statements, but you can load the questions in as they come. Anyone who sent questions initially to myself or Jennifer will make sure to try and touch on them, but you can re-put them into the question box, and we'll get to as many as we can. I think it's slotted for 2 hours. I believe it's a hard stop, but we'll get to as much as we can in that 2 hours. So it's being recorded. So anyone who has to leave early or comes in late, don't worry, it'll all be sent out. I'm not sure how quick it will be because it has to upload the full presentation before it can be sent out, but we expect it to by the end of the week. So without further ado, I'll just go right in the line of how I introduce. So I'm going to open the panel up with Allison White. Allison, can you hear me?
I can.
I'm sorry, right. Allison Wilson, I'm sorry.
No worries. So I thought it would be wise just for everyone to maybe close your eyes unless you're driving. And I want you to take a big breath in through your nostrils and exhale. I know the anxiety is through the roof for probably everyone on this call, but in particular intended parents and surrogates. But I think it's helpful that we recognize that for all of us, this is out of our control. And so when I have patients, be it a surrogate or mainly intended parents, they're already feeling out of control, obviously, because someone else is carrying their baby. However, I look at one of their fears, obviously, is they're going to get this virus or not, and how are they going to be behaving in that way? And I really want you to first validate the intended parent's feelings. It's not helpful to say, don't worry, or this will get better, because we don't know. I'm not an alarmist, but I think it's helpful to go, yeah, I can understand how this feels. However, your surrogate has a vested interest in staying healthy and well. She does not only because she's carrying your baby, but she's a mother herself. And I don't know any mother who would not try to stay as healthy as possible to take care of her children if they're young or old. So reminding the intended parents of that. Again, big pictures out of the control, but then I remind people, but what's in your control? And helping all parties to see, you know what, we need to set some boundaries. It's not, set boundaries on how much news you're going to be reading or social media. When, someone's talking about it or you're starting to obsessively worry, asking, can you change the subject? Also doing activities that help for the parents to feel grounded as they're going through this. And I think it's just helpful for them to look at what I always call what's productive worry and what's unproductive worry. And if you can help them to distinguish if they're spinning out of control or, oh my surrogate's going to do this or that, helping them to remember, productive worry is what we're all about in the team. I tell patients all the time, we are all on Team Baby. We're helping to bring this little life forward, and you're not alone. And we are here for you, so that can be immensely helpful for all parties. With regards to my specialty group and ASRM mental health professionals, what we're seeing right now is the debate: should we still screen surrogates and donors in person? More because of the psychological testing, which is the standard of care to do psych testing in person. And as of a few days ago, the census was, yes, still continue. One, because if the surrogate or donor is going to be seeing the physician one-on-one or in the clinic in person, then they can also see us. That may change. Things are changing rapidly, as we all know. Interjurisdiction counseling, are you able to do that if you're not licensed in a different state? There are loosening that. They're loosening HIPAA rights for us as mental health professionals to provide the care that we need. We're also allowing a lot more video and telehealth for mental health professionals, which can be very, very helpful if people are isolating at home. So again, we're kind of, the question of screening donors and surrogates is really leaning towards still doing it in person. We do social distancing. It's usually a clinician and the person in the room, and that's it. But it is up to the individual mental health professional. So And please know I'm available for any questions that, participants may have.
So now I'm going to introduce Rich Vaughn. So Rich, if you want to.
Okay. All right. So I think Allison's comments were really well taken. I want to say something that's not meant to belittle the situation, but is to speak to all of you who are the professionals responsible for helping our clients and our patients through this process. And I'm not going to take credit for it. It's something I saw on Instagram, but it was a funny quip that I think sets the tone, which is our grandparents were called to war. We're called to work from home and help these parents through this process, surrogates and donors as well. We can do this. I think one of the things that really helps people in situations of sort of panic or crisis is to give them some structure, give them a sense of the outline of things to be thinking through. And so in that regard, as far as the legal aspects are concerned, there are basically 3 areas. I've divided them into 3 areas, there may be more, but 3 areas to think about. The ramifications if a cycle is delayed or not delayed, issues surrounding parents trying to come to the US for the birth, and issues surrounding parents who need to get home with their baby. In terms of the cycles being delayed or not delayed, consider the medical aspects of not delaying the cycle, including medical recommendations from the clinic and ASRM, ESHRA, et cetera. Consider the financial aspects as well if the parents do not delay the cycle, and the cycle might be canceled anyway. If the cycle is canceled, consider the financial aspects that might be an issue in the contracts. Are there any canceled cycle fees, any other expenses that might need to be addressed that are in the contract, or things that might not be addressed in the contract? Because this is an unprecedented situation, not one that any of us could really have anticipated. And there could be insurance questions, issues like lost wages, issues from delayed cycles, or even self-quarantining. There could be some lost wages issues there. For parents who need to come into the country for the birth, parents should be checking with their airlines to see if flights are still on schedule, checking to see if there's a quarantine period, either where they are or when they get here, and they need to plan accordingly. In terms of coming into the country, also looking ahead to talk to the hospitals to see if they have any policies on limiting the number of people who can come into the hospital. We have situations where families might be allowed, but in this case, maybe only one person is allowed. I've had some hospitals actually not allowing a guardian into the hospital, even though the guardian is the only person who can get there. And so you have to plan for those kinds of things and call ahead and find out what their policies are. If the parents cannot be here, do they have, or should they be thinking about permanent, temporary, or standby guardianship documents or powers of attorney documents to give someone authority that can stand in their place and be with the baby? There's been some discussion from a lot of extremely caring surrogates about perhaps acting as that guardian. I think that's a wonderful sentiment. There are some legal risks to doing so, and should be thinking about that carefully. But in a pinch, I would say that as a last resort, that can be worked out. There may be some liability associated with that, which we can talk about later on the call. And for those parents who are trying to come into the country, if they are subject to a travel ban, there are exceptions to the travel ban for parents, legal guardians, or siblings of an immediate family member. And attorneys can be writing letters for their clients explaining the legal relationship between the parent and the child, either if it's already born or child to be born, attaching pre-birth orders to those letters and copies of passports and pre-birth orders if they're available. Sometimes you'll end up in a situation where maybe you don't have the pre-birth order yet, or the baby came really early. So attach what you can. There's no clear guidance yet from Customs and Immigration, Customs and Border Protection, Department of Homeland Security on who should receive these letters, whether it should be the airlines first or the consulate. But consider that the consulates, they're also closing down, going low staff, et cetera, and they may not have an answer for you either. But think ahead on that. Now, for parents who need to get home with their baby, let's say they're here and they're stuck here because of the airlines and travel bans. First, of course, again, check with the airline. You'll need the birth certificates and passports from the US first, and some government agencies are shutting down or going low staff. As far as I can tell so far, and this was from an hour and 30 minutes ago, according to the National Association of Public Health Statistics and Information Systems, most vital records offices are at least still responding to requests. If they're not closed completely, most of them are closed to the public and still processing paperwork, or can at least process paperwork like a birth certificate through a fax, email, or mail request. The other thing to be thinking about is whether there's any quarantine periods going back home into the country. And then one of the other issues that's coming up is I've had some parents try to get here quickly in light of the pending travel bans, and now they're here probably for 2 or 3 or more months because they didn't want to risk missing the birth of their child. These folks are going to be outstaying their visa, and they're going to be have to getting some exceptions to their visa restrictions. This is called a satisfactory departure exception, and USCIS is the department that would provide those exceptions. And right now, this was as of 2 hours ago, USCIS is actually shutting down most of its offices and only handling emergency situations. So it's a little unclear at the moment whether this will qualify as an emergency situation or whether they'll wait until the visa stay is actually about to expire. So those are things to be thinking about and planning for. In regard to the sort of the other legal aspects of this, courts around the country are shutting down. They're going low staff. They may be closed entirely or just closed to the public, reduced hours. LA County courts, for instance, are actually completely closed for 3 days, but opening next week only for emergencies. So plan ahead and look at your lists of births coming up, obviously in March and April, but also May and June, and be prepared. And I guess finally, just there's really no reason to panic, every reason to be hopeful. We will get through this. And I know this because I have a message from the future, which may sound a little corny. I have a paralegal who used to work with me in my LA office who now lives in Beijing with her family. She's been there for several months now. They've been through this and they're starting to come out on the other side. She's recorded the video, which I put up on my website, just to give people a sense of hope that things are getting better, things are improving. She talks a little bit about her experience, her daily life, the extra time that she and her family have been able to spend together and how they've adjusted to these new rules of living. And I think it would be really helpful for a lot of people, especially those with anxiety about what's to come, to maybe see that video. And then I guess finally, if we're talking to parents, remind them they've spent years of ups and downs, lots of research, lots of preparation, thousands of dollars on fertility services, and now they're faced with this. This is not an insignificant bump in the road, but it is something that they can get around. There will be delays in cycles, postponing cycles, and other interruptions, but they will get through it. They've planned so much to get to the point where they are. They can plan to get through this as well.
Thanks, Rich. So next, I'm going to introduce Dr. Feinberg. Can you hear me, Dr. Feinberg?
Hi, the volume for you sounds really low. Can you guys hear me okay?
Yep.
Okay.
I just realized my microphone was at the top of my head, so that's why you couldn't hear me, but you're up to go.
Great. So hi, I'm Dr. Eve Feinberg. I'm a reproductive endocrinologist and infertility specialist at Northwestern. I'm also the president of the Society for Reproductive Endocrinology and Infertility. And I sat on the COVID-19 task force that made the recommendations that ASRM published. So I wanted to share a lot of the perspective that went into this on the back end, how difficult those decisions were for us to make as a task force. We spent a lot of hours over this past weekend speaking with experts from the WHO, infectious disease specialists, looking at CDC, looking at past flu pandemics, and really struggled knowing that the implications of these recommendations would be far-reaching from financial perspectives for the individual patients, for the physicians, for the clinics, for the society as a whole. and the ramifications that these would have. And I wanted to share just a little bit about some of the thought process that went into it. First and foremost, one of our biggest concerns was for the health of women who may become pregnant who are infected with coronavirus. As many of you know, for lots of women who become infected with coronavirus, it doesn't necessarily lead to the full-blown acute respiratory distress syndrome or COVID-19. But for those who do, there's very little that can be done to treat those patients. It's basically mechanical ventilation until somebody recovers or until they die. There's been the use of compassionate antiretroviral medications that have been used. However, Gilead Pharmaceuticals, who is giving the drug for use in compassionate care, has specifically stated that that is not to be used in pregnant women. And so as the recommendations were being developed, we felt like hopefully this would just be a very short-term pause in the way that we do things. And as many of you probably noticed, the document is time-stamped, like we will reevaluate these recommendations in 2 weeks. We felt like we had to take drastic measures to prevent new patients from becoming pregnant because of the impact that pregnancy may have in the ability to treat these women. And from a very dire social health perspective, looking at the experience in Lombardy, Italy, and how rapidly the virus infected thousands of people, leading to over 2,500 deaths within the matter of days. One of the greatest strategies that society can do is this concept of social distancing. And with a large volume of patients coming through the doors in a reproductive endocrinology clinic, we really felt like it was necessary, to put our foot down and say that we're going to do our part as a society to not increase traffic and not increase the number of people who were overlapping in a clinic, in a waiting room, and from a general health perspective and utilization of resources. While the majority of ART cases are extraordinarily safe, there are complications, and patients do end up in emergency rooms with things like ectopic pregnancies or ovarian torsion or OHSS. And by immediately pausing ART cycles, you'd be increasing the burden. You'd be decreasing the burden on the rest of the healthcare system. And so the recommendations were really like several pronged, but aimed at the approach of let's prevent the onset of new pregnancy and let's pause fertility treatment. Let's halt ART cycles so that we're decreasing the burden on society and we're increasing the ability to proceed with social distancing. And then from a pure gynecologic standpoint, gynecologic surgery, which obviously doesn't impact this group, but the decision was also made to comply with national health recommendations for pausing elective surgery. And so, it was a very carefully crafted, thoughtful group of people who put together these recommendations, really with the thought process of, if we can nip this in the bud, if we can do this in the very short term and immediately do our part, work together as a society, halt treatment, that the faster we could get through this, the faster that we could return to normal care of patients.
Thank you, Dr. Feinberg. So up next on the list is Sarah Page. Sarah, I'm gonna get you live. So, are you there?
I'm here.
Thank you.
Okay, well, let's get started. It's a joyous thing. So essentially, kind of what I wanted to go through is a couple things. Number one, CMS has come down and definitely said that any lab work or treatment of the COVID-19 coronavirus should be covered by the Affordable Care Act. So that's something to keep in mind for anyone that's on an ACA Affordable Care Act type plan. Something to keep in mind if they are on a, let's say, Lloyd's syndicate, so either a New Life agency and or universal family, that what we're seeing is that there is an exclusion within the policy for infectious diseases. And so essentially, if there's not a reason that it would complicate a pregnancy, then there would be no coverage for the treatment or the diagnosis of that. So that is something to keep in mind. Of course, it is a maternity only policy. And so with it being maternity only, if it's not affecting the maternity, then it wouldn't cover that portion of it. One of the things with the Affordable Care Act that we're starting to see really roll out is that the enrollments dependent on state are starting to be special enrollment specifically for COVID-19. And so right now, the states that have opened for special enrollment are California, Connecticut, DC, which is not a state, province, Maryland, Massachusetts, Nevada, New York, Rhode Island, and Washington. And currently Vermont is being discussed. Those states are all off of their own exchanges, so not through healthcare.gov. Healthcare.gov and the federal exchange has not stated what they're going to do. They've actually been very silent since about March 6th. And so we're hoping to hear from them. There is some legislation they're trying to push through right now that would open it back up and clarify specifically what they're willing to cover in terms of diagnosis treatment of that, including telemed as well as home health. So there's a little bit of unknown surrounding that. The other thing that I wanted to touch base on outside of just the maternity portion of that of insurance is, of course, the accidental death term life situation for life insurance / life insurance alternatives. So with the life insurance portion, if it is a term life policy, so far they are stating that they will cover any sort of death passing away from the COVID-19. However, the accidental death policies, which both Universal as well as New Life and other insurances, if they are AD&D, are saying they would not, because the way the policy is written, it does not cover a death due to an infectious disease. So that is something also to keep in mind. Moving forward beyond this, Lloyd's of London has put out kind of a mandate, I guess, stating that they will absolutely put an exclusion in any new policy going forward for COVID-19, and that is for any Lloyd's policy across the board that came from the top down. So just so that you're aware of that. The other thing, of course, to keep in mind with the cycles is that if there is any complication due to the COVID-19 for any sort of either embryo transfer and or pulling of the eggs from the donor, that they will cover the complications due to that, but not cover any complications due to COVID-19, again, infectious disease. So just some things going on with there, trying to get more clarity surrounding, well, what happens if there ends up being a complication, not just from COVID-19, but it actually ends up complicating the cycle. What happens at that point in time? I don't have full answers yet, but I'm working on getting those. And then the only other thing that I do know right now is that both the Universal as well as New Life with their products are willing to put basically a freeze on any policies that have been purchased for the accidental death as well as the cycle insurance until this is kind of subsided. Right now, they're willing to do a 90-day freeze. So if anyone does have insurance right now, even if they have started meds but can't actually cycle, we're just putting everything, they're willing to put everything on a hold. And I will get further information surrounding that and be able to send that to everybody. But we're trying to work through that as much as we possibly can, because we do understand we don't want people to cancel cycles because there is some risk that's still involved with it. But trying to figure out what the best thing to do is so that we don't, have to cancel everything, but still allowing people to start as soon as the clinics are ready to start. So that's what I have right now, but I'm absolutely willing to filter questions as they're coming in.
Thank you, Sarah. All right, so next up is Mr. Steven Snyder from IARC and the past co-chair or chair of the American Bar Association's Assisted Reproductive Technology Law Committee. Mr. Snyder, can you hear me?
I can, Mr. Hutchinson.
You're good to go.
Thank you. So I have the privilege of having taken over what is by consensus the first surrogacy agency ever established in the US. It was established in 1982 by Noel Keene. And believe me, in the 40 years that that agency has operated, we have never seen any situation like this. I started working with Noel in 1991 as their local counsel in Minnesota. So I've seen a lot in the 30 years that I've been doing surrogacy law. My comments are going to be a hybrid of some agency observations and some legal observations. As much as possible, I will try not to repeat Rich's comments, which were cogent and logical and wonderful, and not preempt Wendy and Jennifer's comments, but there are overlaps. I think the first thing we all have to accept, and this is something that I think Allison touched upon and foreshadowed, when I talk to intended parents that are working through our agency, my first platform is understanding. I do not minimize their stress or their worry. My second is accountability, meaning I'm here as an agency, and it may not be my fault, but it's my responsibility to support and solve problems. And that leads to the third, which is support, emotional, professional, organizational. We have to be there, and we cannot allow our stress or our fear to leak into the advice that we're giving to our parents. So it's a challenge for us. None of us have ever faced it, but I know that each of us have hearts that are oriented toward giving those things, or we wouldn't be doing what we're doing. When I think about an agency owner, I think I'm blessed because I am an attorney, so I can operate in both hemispheres of my brain, agency and attorney. If you're an agency owner that is not an attorney, my first admonition is find competent counsel in your area. I'm sure you already have that for referral, for parentage proceedings, for contracts. You must lean on and interface with that local attorney because there are 50 different sets of parentage laws in the United States. The law in the state of your surrogate or the transfer or the intended parent's residence may apply. You need to have an attorney in the relevant jurisdiction of the applicable law to be advising you because your answers are going to vary to legal issues state by state. If you have a problem identifying what state that is, I think Rich is a great resource because he has a national network. I am also a resource and would be happy to help. But make sure that you are getting competent advice from someone in the jurisdiction of the law that is going to apply to the circumstance of your surrogate, and that is not going to be consistent surrogate to surrogate to surrogate. It will depend on where they live. When you talk to those attorneys, they're going to have different legal issues, and I'm going to state some generalities without giving answers, and then we can answer questions that have been culled and assembled by Jennifer White as part of the preparation for this conference. But you're going to have questions about the contract. You're going to have questions about monthly support payments to surrogates and whether they should continue. You're going to have other questions about restrictions on the surrogates and are they addressed for COVID-19. You're going to have questions about the parentage process, and that is going to vary depending on whether you're a pre-birth or a post-birth state for your particular surrogate. California questions are all going to be pre-birth. Minnesota, for example, where I practice, or Wisconsin or Missouri or a number of other states are going to be post-birth states. And the issues are going to be totally different and turned upside down. When you talk about that parentage process, you're going to be talking to the court and what the court process is and whether the courts are open. In Minnesota, and this is just 1 out of 50 states, We have a 3-step process for surrogacy that may, at its most complex, involve parentage, termination of parental rights, and adoptions, all of which the court has identified as low priority items not to be prioritized for hearing during their suspension of, or limitation of services. However, when you combine all 3 of those in a surrogacy, it becomes a high priority matter, and the interface of the legal community with the courts has put the surrogacy matters back on the calendar for courts in this emergency situation. And that will also vary state by state. And then you have legal issues that aren't controlled by the attorneys, but are important to agencies, especially if they're international parents. And again, your issues as agencies are going to differ between domestic intended parents who have many more workarounds and solutions, and international parents, which have limited workarounds and solutions. And when you talk about the international parents, it becomes critical time-wise that agencies that attorneys do not control, not only the courts, but the birth certificate office, and whether they're open and whether they're prioritizing international processing of birth records, or they are putting them at the bottom of the pile with restricted staff. Again, in Minnesota, those are going to the top of the pile, and they are emergency issues that the limited staff is processing, but you need to have your attorney or your staff check to see if that's the case and be advising your parents, especially if they're international, accordingly. And then you have the passport office. And I talked to our local passport office because we do have a physical passport office with walk-in capability here in Minneapolis. And the adjudication officer there said, look, I'm going to tell you what the circumstance is today. It could be different tomorrow. That's how fast things are changing. We are still accepting in-person appointments for people that are 7 days from travel, but that could change tomorrow. Check our website every morning to see if your appointment is still on. And G, at the entrance to our building, the security staff may be stopping anyone from a restricted country that has travel restrictions, i.e. all of Europe. And they may not let them enter the building. So even if they have their applications and they have an appointment, they may not be able to get in, which leads to creative problem solving of having a dual parental authorization for some third party that lives locally that's not subject to those restrictions, take their children in and get the passports for them. I think it's a form 3053. So there are workarounds at the passport office. They are still working, but that is going to change day by day, and you have to be aware of that. When it comes to the care of the children, as Rich said, there are guardianship issues, and there are issues of risk. You have to make sure you have a negotiated release and indemnification agreement between the intended parents and whoever is going to care for the child. You have to specify whether there is consultation and what kind of consultation before medical decisions are made for the child if the intended parents aren't with them. You have to find documentation to protect the people that are providing caregiving services from liability for those services, and to structure them in a way that the intended parents have maximum input and control over those decisions during the guardianship. I'm going to let Wendy talk a little bit more about who those caregivers might be. And those guardianship documents are going to be different state to state. In Rich's state, if he gets a pre-birth order, and Rich, I hope you do in every damn case, the intended parents are the ones that have to sign the authorizations. If you're working with a surrogate in a post-birth state like Minnesota, at birth, that surrogate is the parent until the intended parents get here to participate in a legal proceeding to change that, which means the people that need to sign the authorizations for guardianship are the surrogate and her spouse, if any. And that also takes coordination with the intended parent. So you're going to have different landscape in different states depending on who's the parent based on the law of how and when parentage is established. The whole stages of pregnancy I'll let Saeed talk about, but you're going to have cases as an agency that are going into transfer that haven't started meds. I think those are the easiest. You're going to have transfers where they have started meds and are incurring costs, and you're going to have to talk to the clinics, and the clinics are going to have to determine whether they're going forward with those transfers to save expense. You're going to have the surrogates that are pregnant, and the risk, especially again, different for domestic or international, is going to be dependent on how pregnant are they. Are they 9 months pregnant and going to deliver next week, and we have an international parent here? That's a whole set of complicated issues. Or did they just get a pregnancy confirmation, and are they going to deliver at the end of this year? Oh God, let's hope the landscape is different by then. And then those people that already have children that are born and are here under various status, and then we get into what are the hospitals doing, and then Rich and other attorneys like them and the attorneys you interface with in the state of the surrogate's residence and birth are going to be critical, because they have to talk to the hospital council, figure out who can and can't enter the hospital, what workarounds there are. And I'm telling you, the surrogacy attorneys don't have control over that. The local state government, the hospital association, the hospital attorneys are going to dictate that, and we're not going to be able to change it. We're just going to have to roll with the punches. So at this point, I'm going to defer and answer questions if there are any. And I just want to thank each and every professional on this panel for spending their time. All we want to do is give you whatever knowledge and experience we have, make your jobs easier, and support everybody in this process and this system, not just the people that are our clients. Everybody that's a human being that's trying to have a child needs all of our support. Thank you.
Thanks, Steve. All right, I'm going to introduce Dr. Saeed Danishman. Dr. Danishman, can you hear me?
I can, Dean. Thank you. Hello, everyone. It's good to be part of this wonderful community during these harrowing times. What I wanted to do is talk to you a little bit about some of the medical aspects of IVF and how they're affected by this particular pandemic. I'll start off with some of the questions that some patients have had, some surrogates have had in regards to vertical transmission, meaning from the surrogate to the fetus or from the mother to the fetus of the COVID-19 virus. There was a recent study that was published in the journal Lancet, which is a very prominent British journal. And what they looked at is they looked at about just about 10 cases of pregnant patients who were admitted to the Wuhan University with symptoms of pneumonia. They were then diagnosed with pneumonia secondary to COVID-19. So what they did in those particular patients, all of them were delivered via C-section, and then they looked at the presence of the virus in cord blood, in amniotic fluid samples, and then after the birth of the newborn, they did nasal and oral swabs for the presence of the virus. The good news out of Wuhan University was in that particular study, albeit a small one, there was no evidence of the virus. And so we think at this particular point, that despite the fact that the studies are limited, that the chance of vertical transmission is low. We can't rule it out because I think further studies are needed. And Dr. Feinberg and I were talking today about this situation. But we think there's more studies, but I think that the risk of transmission, much like the risk of transmission with many other viruses, because there are other coronaviruses, other rhinovirus viruses. If you look at the influenza virus, for example, there are other corollaries where we don't see that vertical transmission. So some good news out of Wuhan universities, and I can certainly send you the link for that particular study. The other issue in regards to IVF is, what are the risks associated with sperm contamination or eggs or even embryos from the virus? There's, again, very good studies, not on the coronavirus, this particular COVID-19, But on other viruses, for example, there are corollaries with hepatitis and HIV, and we don't see any evidence of transmission of the virus or viral particles with sperm, with egg, or in embryos. And subsequent embryo transfers that are done to patients, we have never seen a case of viral transmission of these particular viruses to the mother or to the surrogate. So we feel that there's pretty good evidence of a lack of risk, an absence of risk in regards to sperm and egg. And of course, we have very vigorous, all fertility centers have vigorous washing techniques for sperm, for egg, and very sort of vigorous culture conditions for embryos as well. So we think that that risk is non-existent. The other issue is, and I think this is something that the ASRM, American Society of Reproductive Medicine, in particular, the task force was concerned about, is what are the risks associated with pregnancy? When you look at the studies on pregnancy, there are not that many studies looking at this particular outbreak, but there are some studies, some published, for example, in 2008 with the other SARS epidemic, looking at pregnant patients who had evidence of symptoms and were infected with the virus, with the influenza actually virus and the SARS. And when you look at those particular cases, there are reports of an increased risk of complications in the first, in the second, and possibly the third trimester. In fact, there was one study that looked at mortality rates among pregnant patients who were very sick, and that seemed to be comprised about 5% of the group of patients they looked at, and those group of patients who were pregnant only comprised about 1% of the population. So we think that there is a possibility, and again, if you look at the CDC website right now, the CDC will tell you that we don't know enough, we don't have enough information at this particular point to determine whether pregnant patients are at higher risk. But if they were to get very sick, then, as Dr. Feinberg mentioned, the treatments may be limited because some of the antiviral agents that are being developed right now, for example, by the company Gilead Sciences, may not be able to be used for pregnant patients. And there is also a possibility that pregnant patients may comprise a higher risk group that may have more severe symptoms if they were going to become pregnant. And so to that end, I do think that having a pause of at least some weeks in regards to pregnancy is something that should be recommended and is a very logical conclusion based on the particular pandemic we are facing. It's also important to note from a public health perspective that the ASRM recommendations also wanted to address the public health factors. We know that these sort of social distancing recommendations are based on, for example, some of the work that was done back in 1918 with the flu epidemic, where when you look at, for example, the flu initially being detected in Philadelphia, the rate of rise of number of cases and the number of people who were severely affected there was a significant number of them, and so there was this rapid rise in the number of cases because initially the city of Philadelphia really didn't take the flu very seriously. They didn't implement any social distancing restrictions, and so people were still gathering in large numbers, and so the number of cases increased very rapidly. And the system was overwhelmed. Now, when you look at the flu in St. Louis, and you look at it about a month and a half later in St. Louis, they learned from the lessons of Philadelphia, and what ended up happening there was they implemented restrictions very quickly on large gatherings, and so the impact of that 1918 flu epidemic in the city of St. Louis was muted and was less. In fact, that's how we sort of get this notion of flattening the curve, meaning the absolute number of cases that are diagnosed each day are going to be much lower. The number of days that we may be diagnosing cases may be longer, but the number of new cases each day will be less, and so the healthcare system will be less overwhelmed. So I think in that particular regard, we all have to come together. We all have to really band together to be able to pass through this particular pandemic and come out the other end, as one of you mentioned. And I do think that all of you, all of us can contribute, and we are going to get through it. Again, when Rich talked about the fact that in China, they were able to implement very strict restrictions on gathering, some quarantining, and these particular restrictions actually helped to stem the tide of new cases each day. So I'm very hopeful. I do believe that we're going to have a pause, but the pause will be temporary, and we will look to the leaders in the field, the experts who are going to band together and lead us through this particular pandemic. Thank you.
Thanks, Dr. Danishmand. So next, I'm going to introduce Jennifer White. Oh, let me unmute it. Jennifer, can you hear me?
I can hear you.
All right, you're live.
Yay. I don't want to step on a lot of people's toes because a lot of great things have been said, but I just have two quick things that I'd like to shout out there to the world. I really appreciate that we as a community are coming together and helping each other. That is huge and just helps make the panic a little less. One of the first things that I'd like to point out that is a resource to people out there is I know we have a lot of people who are very worried about intended parents who either can't make it and might need temporary guardianship, and possibly your agency is not nearby. Carrie Flamer Powell has put together an incredible spreadsheet via the Surrogacy Professionals page on Facebook. I know that it has where people are willing to step in and act as a temporary guardian, and where they are located or what areas they're willing to go get children from to be able to act in that regard. I know not everybody may be on that page, and if that's the case, I'm more than happy to act as a liaison on either side. If you have a need, I can reach out to Carrie and we can go over that spreadsheet, or if you are willing to offer, you can definitely send an email to my SEEDS ethics email address, and I will make sure that we get that taken care of. It's just so important to pull together and take care of that. The other thing is, and hopefully this is a small percentage of people that are affected by this. It's a small subset of everybody, but I'm in a unique position that I am married to a commander at one of the military bases in the United States. So I get to hear a lot of the emergency ops and things that are going on in the background there. So as military, and especially if they're acting as surrogates, we are under 2 stop movement orders, and our civil liberties are a little different than everybody else's in the United States. So there's an international stop movement that says that both active duty military and their dependents, we are actually prohibited from traveling overseas at the moment. And that is to be lifted no earlier than May 11th, and it will be revisited at that time. The second one, the thing that has caused people a little bit of confusion, is there's a domestic stop movement as well. Same thing, it is to be lifted absolutely no earlier than May 11th. That doesn't mean that it won't be extended longer. The difference on that stop movement is that it only applies, so it applies to active duty 100%, but it only applies to dependents if they are not traveling on official orders. So if a dependent is being PCS'd and the government is paying for their plane ticket, then it affects them. But dependents may move by themselves. They may go wherever they would like in the United States of their own free accord and of their own free will. The biggest reason that this could potentially be an issue for your surrogates, because obviously they can travel themselves, but if they are at a clinic that requires, especially as we get through screening and as things start to release a little bit, that needs both the partner and the gestational carrier there in person, that active duty member might not be able to travel to that screening appointment. So you want to keep a very close eye on that. The other thing is if they plan to use their that active duty member as their companion, you might need to make special arrangements for that. Again, it's going to be readdressed, but we've been told, and my husband just popped his head in just a few minutes ago, and he said it is still 100% not to be lifted any earlier than May 11th. So we're on a slightly longer frame than everybody else. So that's what I've got for right now. So I'm gonna pass it on to Wendy, I guess, next.
Thanks, Jennifer. Let me get Wendy. Wendy, can you hear me?
I can hear you.
You are live.
Okay. Hi, everybody. I guess first I just want to give you all a big social distancing, safe virtual hug. And if you need to go get an adult beverage, now might be the time. But also, I just kind of want to reiterate what Allison said and thank her for that. It's a good time for everybody to take a very deep breath. I have to remind myself that several times a day, not only just because of everything that's going on in the world, in our business, in our industry, suddenly becoming a teacher, a mom, and everything at home. But I think it's just important that we all take care of ourselves because we have so many other people that rely on us during this sensitive time. And also, as Rich was saying, I kind of made a little note about it is, you know, our IPs have already been through so much on their journey here to even reach out to us, to ask for our help to somehow figure out a way to budget this. And now on top of everything else, they're having to deal with this unbelievably unusual situation that nobody really even knows how to give them direct answers about. But my theory is that they are going to end up being the best parents because they are going to learn huge amounts of patience in ways that maybe not all of us had to be put through. Another thing I want to talk about, because I'm speaking on behalf of SEEDS, our national ethics group, and agencies, because that's what SEEDS is. We are a bunch of agencies that have got together to try to figure out the best, most ethical path forward in this industry in every way, including this. And how much more we all need to come together now, because one of the things SEEDS has always said is it's not our small group making rules for the rest of the country. It's all of us coming together and determining the best route forward in any situation, but including this one, of course. Maybe this one most importantly, because it's going to put all of us up against the wall. I know there's probably a lot of agencies on here, and I don't have a huge agency. I'm more of a boutique agency, and I already wasn't sleeping last night. I was staying up worrying about so many different things, including how long is this going to last? Am I going to be able to afford to continue paying my employees? What do I do about the several intended parents who have been reaching out to me and saying, do we put this on hold? Do we make our next payment? Can we postpone this until everything is over? Another one of my good friends said they lost 8 matches in the last week. And for a lot of agencies, those 8 matches are really determining whether or not we can stay open or not. And so I'm addressing this both as our ethics group, but also as a fear for agencies, because we don't have a lot of the same resources as other people in this industry to be able to keep going. And so I started reaching out and asking different people what they were doing. And right now we do have options. There is the federal loans opened up for small businesses. And so it's an area that agencies can already begin to look into. A lot of time there are state loans in many states opening up as well. And again, I can't say whether or not that's the right thing for your agency, but as a lot of people were reaching out, it's just something that, had you not have thought about it, maybe I can just put that out there to see if that's something that would benefit you. Another thing is how to reply. One of the questions that I got a lot today was, how do you reply to intended parents saying, I want refunds, I can't move forward, we don't know what's going to happen. And one of the things that I was talking with a lot of other people about as well is, if I were to give refunds to every single intended parent who asked right now, they wouldn't have an agency to come back to in the future. Let's say this goes on for 6 more months, and I want to be able to be there for them. So I would like to come up with what I think is a good ethical response and a fair response to agencies that are, I'm sure, getting the same questions that I am. Both Steve and Carrie both touched on out-of-country IPs that have babies due within the next 6 months, and we have no idea what's going to happen. I know a lot of my IPs that were having babies due in the next couple of months that lived in Europe, Israel. They chose to come here. Some of them can't. The babies are too far out. They can't do that, and we don't know when this is going to end. And so Carrie Flamer-Powell's group of resources and surrogates and people willing to help is fantastic. I think right now what we are talking to each set of IPs about is, first and foremost, the most ideal situation is who do they have that they could potentially get to be power of attorney, care for the babies. That might be local. So a lot of the intended parents that I know do have friends and people here in the United States that might be able to help. That's obviously optimal, especially if it's family members and close friends. Things we would never suggest in the past, but we have to open the door to new ideas and new possibilities are the surrogate, if she meets certain mental health standards, to be able to do this. Our previous surrogates who are stepping up in ways that is so unbelievably moving that I teared up a couple of times today because I've had so many people reach out about that. Agency staff and agency owners who are also stepping up and willing to do that. And as Steve said, obviously there has to be legal protections put into place for all of this, but things that we never thought we would say out loud with regards to guardianship are now all on the table. And getting as much feedback from everybody else as possible would be fantastic with regards to that. At this point, those were, almost forgot, as far as the SEEDS conference, I know that's honestly, with everything else going on, it's probably the last thing on people's mind, but I do know that some people asked for an update. At this point, because we don't know how long it's going on, we did a majority vote, and at this point, we're just going to wait till next year. So we already had dates on the book for 2021 that we had put out there, and we're going to go ahead and keep that and not try to figure out a time in the fall or winter that we could do it, or even, you know, right after the new year, because I think it would just be too overwhelming in the wake of everything that's going on. That being said, we do feel as an organization, especially because it's so important to have all of you as part of it and hear your voices as well. We were hoping to have maybe monthly webinars, sort of a brown bag lunch, if you will, to just talk about the different changes and everything that's going on with all of the different professionals in our industry being able to weigh in and hopefully provide feedback that's incredibly important so that we're all responding in a similar voice equally, and we all know what to say when different things come up. So that is that is mine for now. I just want to say one more time, I hope everybody hangs in there. I've even noticed the jokes about the virus have changed from toilet paper and political or washing to how do we keep our businesses open and how do we continue to pay rent and our relationships with one another. So that's the most important, our relationships with one another. And I hope we can all maintain that. And for anyone who needs to hear it, you are definitely loved and supported, and please don't hesitate to reach out. Thank you.
Thanks, Wendy. So I'm about to open up all the questions. I just wanted to kind of jump on what everyone else is saying and say how honored I am to be a part of this field. Everyone here jumped at the chance to speak. It started with a text between, I think I sent it to Steve, and Steve sent to Wendy and Jennifer, and Rich got involved, and then Dr. Danishman, and then Steve reached out to ASRM, and they got us Dr. Feinberg. and we got Allison as well. And when we reached out to Sarah, she quickly jumped on. So just in 3 or 4 days, we put this together. I hope it's been helpful so far. I mean, I think we do amazing things as a group, and even though we compete in certain ways, there's never been anyone who's refused a request or a question or a quick phone chat of all the people. And I'm happy too that for once, kind of our different groups where we have all of our different conferences and we meet, you know, the ABA has their conferences, ASRM, SEEDS, Quad A, but it's nice where all of us can get, we're not in a room, but on this feed. And we will definitely have more to come after tonight. And I think what Wendy was saying about future teleconferences and brown bags, we should do it as a full industry, because we're only better when we hear from all the different parts, rather just lawyers or just doctors or just agencies. I think it's wonderful when we can share the spotlight together. I wish we did have a video. I think it would add some levity. I'm honestly sitting on a third grader's desk in a wooden chair because I had to get as far away from my children as possible to there wouldn't be feedback. So I'll try and circulate the photo later that I sent to our group here of me sitting in a student desk chair. But with that said, I'm going to turn everyone's mute off. If you want to self-mute each other and open up when a question is something in your wheelhouse, I can do that, but otherwise just try not to step on all the answers. But let me see. Taking you all off mute. Okay, so questions, I'll start them at the beginning. I think there's a hard stop at 10:30, just so you all know, and we'll try and get to everything. There might be some feedback.
Yeah, I think if somebody has something on speaker, it's giving feedback. So,
okay.
So make sure you don't have it on speaker.
So the first question is regarding gestational carriers that are pregnant and are expecting their due dates delivery within the next few months, and intended parents may not be able to fly due to restrictions. What are the different options currently being reviewed? I think some of it's touched on, but if someone wants to jump in and give just a highlight on those.
Well, Dean, I can kind of look at it as an agency owner and an attorney. So the first question is, can they get in the country? And there are workarounds. I have parents, I've had one set of parents that had a child born, and thankfully one of the parents was an American citizen. So that solved that problem. One of the questions is, can they get in the country? Are they from a restricted country? Can they fly to another country and stay there for 14 days and then fly in from that country? That has been a workaround in some cases. So I've had parents from Europe fly to Mexico, stay there 14 days. Mexico is not restricted, then they can come in as long as they've been there 14 days. Check on those possibilities. If they're in a restricted area, they cannot, I can't conceive of why they couldn't work around it that way, but if they can't due to their personal circumstances, what you're going to have to look at is who's going to care for their child while they put together a travel schedule that will work. And that will depend on when the birth occurs. If the birth is occurring within that travel time in that 14-day window, then you have to have someone here. And Wendy kind of went down the options. Optimal is a friend or family member in the country that can do that, or that can fly in from another location that's not restricted. That's an option. The surrogate, and I'm sure Allison will weigh in on this, our concern is we don't want to put the surrogates in an emotional place that's not comfortable for them. Individual surrogates will have different bonding strength. Different parents will have different trust in their surrogate. I think that's a discussion you have to have with the parents. And then you have to make sure the surrogate goes to Allison or some other mental health professional to be screened before that option is even implemented. A less emotional connection is previous surrogates, many of whom of my agency have reached out and said, we'll help. They're not going to have the bonding issues. And I'm kind of curious what Allison would say about that. And then you have the agency staff and owners. You know, I have 4-bedroom house. I have 3 empty bedrooms. Gee, I love babies, but I'm not sure I'm the best choice. So there are workarounds to get in the country. They're going to be individual to your particular parents. You should brainstorm with your staff and the attorneys in your area as to how to get around those. But I know that Wendy has had multiple cases where she has had to get powers of attorney and guardianship documents for Italian parents who could not show up for birth. And it can be accomplished that someone here that's unrelated to the parents or the surrogate can get authority. And again, Rich may have some ideas about that, so I'll pass it off.
Okay, so actually, while you were answering, Steve, I just got a message from parents who are stuck here. They have their baby, they got here before the bans, and the airline won't let them check in because the baby is not German. She's US citizen, so she's banned from traveling back to Europe. I missed what you were saying at the end, and I'm sorry about that.
Well, that's the first time I heard of that, but you know, we are going to hear about these unique circumstances time and time again, whether it's intended parents not being let in the hospital, babies being US citizens that can't travel to Europe. That's a new one. Explain that one.
Yeah, if you look at it in the reverse, with the travel ban that the US has put into place, you know, someone is allowed to travel here if they can show that their family or sibling or guardian, legal parent, etc. So I don't know the ins and outs of the European bans, travel bans, but it may be that if the German citizen, they can bring their German baby back with them to Germany. So in that case, I mean, I'm just literally going off the cuff, having just received this seconds ago, that they're going to need to go to the German consulate here and get recognition of the child under German law, because the child isn't registered as German yet, and then maybe that will get them on the plane. I think you were talking about the opposite of parents trying to get here, right?
Right.
Yeah. Well, so far, these travel letters that we've been told, you know, should work, could work, we've seen some that didn't work and some that have. And the letters, you know, are from the attorney saying, this is my client, they've been involved in a surrogacy, they have a contract, we have a court order, if we have one, and you attach all the documentation. So what I was speaking to earlier was that it's unclear from USCIS, Department of Homeland Security, and CBP whether we should go directly to the airlines with that documentation, and if the airline lets you on, great, or go to the consulate first. I think if I were the clients, I'd try the airline first. Right now, as of yesterday, the USCIS issued a bulletin saying they will suspend a rule that's normally in place for airlines that puts them on the hook for sending people back if they let them on the plane and they didn't have a proper visa. Usually the airline has to pay to fly that person back where they came from. They're suspending that right now because of the current situation. So I would gather, you know, and just take a guess, that's all we have at this point, that the airlines can have the authority to decide whether the paperwork is sufficient. But that's still a guess. But that's the paperwork that we've been told to prepare. And if you have a court order, it's all the better.
Yeah.
So one of the things on that letter, Rich, is that my understanding it's a basis that you can travel into the country for if you have a relative or a child or someone here. Is that correct? Rich?
Yes, I had to unmute myself. Yes, correct. Now,
so in a pre or post birth state, that letter is going to be of different efficacy. Because in California, you're going to get an order that says upon birth, the parents are the parent of that child, and that gives them a basis to claim standing under that protocol. In Minnesota, when that child is born, purposefully, that child is going to remain the child of the surrogate until the parents get here and participate in the court process to change it. They're not going to be able to claim they have a legal child because that's not the case. Do you see that as an impediment under that process?
I think
Yes.
we need to be mindful of, what the laws are in each particular state, as you said earlier. I think you can make an argument, for instance, under California law that, you could make an argument that if the contract that they've signed is proper and compliant with the law, then for all intents and purposes, they are the parents. They just have to go to court as a formality to get the court order. So that's at least the argument that I'm going to make in my paperwork if it's a pre-birth setting where I'm writing this letter and the baby's not born yet. But I think you're going to have to apply, the circumstances in each particular state.
Yep.
Steve and Rich, thinking off the cuff, even if, let's say your surrogate is in Minnesota, but you did your IVF in California, and the birth is not till June or July, whether Minnesota would accept a California court order or not, is one of those potential workarounds. Let's just get that pre-birth order on right now through California if we can. At least we have this secondary piece where the intended parents may be able to use it in a visa situation, to say, I am the parent, even though it's not born yet, I'm at least been adjudged by a court of jurisdiction that I'm the parent, and please let me travel.
I think that is a huge educational piece for agencies that are on this call. Agencies in the legal arena, jurisdiction, what state can enter the order, is a matter of choice of law. And in the contract or by consent, the parties can select a jurisdiction as long as it has sufficient context. There's a California statute that I'm sure Rich will affirm that says if the transfer is in California, California law can apply. And even if you had a situation where another state of residence of the surrogate was planned to be the state of jurisdiction, you can change that to California, get a pre-birth for travel purposes. That may affect other issues. You need to talk to the attorneys involved. You can also shift jurisdiction based on the residence of the surrogate, which is most common, or the residence of the parents if it's a domestic case. So there are options there. There are nuances. It's a complicated area, and it will depend on the experience and knowledge of the attorneys that you are consulting with in the relevant jurisdictions. If some of them aren't familiar with this, I would bet dollars to donuts, either Rich or I or other more experienced attorneys would be happy to interface with them and guide them at no cost, just to make sure things are getting done and that they know what all the options are. Rich, do you have any other comments?
Yeah, I'm going to add one more thing, and I know, Dean, you want to move on to other questions. So the other thing I would say is we're going to have to get creative. Lawyers, all of us in this business are going to have to get creative and think outside the box possibly. And one other outside the box possibility here is with these letters saying that these are the parents, maybe we attach an affidavit from the doctor. If there's a genetic connection, use that to your advantage and say, this is the genetic parent, and have a letter or affidavit from a doctor. So that might be another option. So I think we should move on, though.
So there was a couple comments, but I'll get just to the questions so we can get through them first. So one person asked, the first speaker, which I believe was Allison, had mentioned that HIPAA has been relaxed. How has it been relaxed?
This is Eve Feinberg. We've been using telehealth, and I think it's been actually quite remarkable how the federal government has come up with new laws regarding reimbursement of telemedicine visits, as well as the ability to use non-secure platforms, which previously were prohibited by HIPAA laws. So we've been using things like FaceTime, GoToMeeting, Zoom, so that we can have face-to-face contact with our patients. And while the reimbursement is a fraction of what it is for an office visit, I think it allows practices some sustainability and some ability to maintain patient flow for the future, and also from a mental health standpoint to really provide that face-to-face reassurance with patients.
I agree with Dr. Feinberg. It was really more the relaxation of the platform that you're using. It doesn't have to be necessarily HIPAA compliant for now, which does allow a lot of clinicians and clients or patients to be able to do the telemedicine.
Okay, so the next question, it's illegal, but it's probably more of a whoever has the question is basically if they have parents here that are still waiting on a passport, they had intended to stay through the end of April, but are wondering if they should get out of the country as soon as possible once they receive the passport in case of they're getting stuck. I mean, from a legal standpoint, I don't think it really matters. Obviously, we don't know what other countries' rules are going to be. I would expect, I think just knowing our colleagues here, Stephen Page, who's went back to Australia recently from a trip, that I believe all Australians coming home are subject to a 2-week quarantine, regardless of whether they're coming from the US or anywhere else. So it's their own, they have to do it at home. But, if to be safe, they want to make sure they get home, then yeah, probably the quicker they can leave, the better. Just in case their own country begins shutdowns and they have to go through a visa process through their own consulates, et cetera. I don't know if anyone else wants to jump in there.
Well, there are myriad of issues relating to passports, and it's all going to be dependent on what the federal government does with the passport offices. Remember, you can do mail-in passport without expediting, which is going to be 6 weeks. That's probably too long. You can do expedited mail-in export through A-Briggs or other passport expediting services that don't require in-person appearance and can be expedited in a couple of days. Now, most of them have to appear in front of a passport agent at a post office or some other venue, and those restrictions are going to have to be determined. Or you can do in-person walk-in if you're within 7 days of travel. So there are multiple ways of getting passports with different timing. And the fastest is obviously going to be the best, which is either the expedited passport agency or the in-person. But the in-person has to be within 7 days. And what I heard from the passport office today is that at the entrance to the passport office, they are asking if the persons coming in are from restricted countries. And in some cases, if the answer is yes, they won't let them in. So you have to do those consents for someone else to go in. So passports are nuances governed by the government, and it's going to be a shifting landscape.
Okay. Next question, it's directed to Rich. Rich, should we expect to see legal language in contracts moving forward similar to what we saw during the Zika stage? And should current contracts be amended to add language concerning the new COVID virus?
That's an excellent question, one that I actually thought about and talked about with a colleague, Michelle Keys, who may or may not be in this call, but I have some hesitation about adding specific language here. With Zika, it was a little different. It was, don't travel to a Zika zone, which, for the most part, didn't include the US. Here, Corona is kind of everywhere, and there are high-risk areas everywhere. There are bans and restrictions and lockdowns in a lot of jurisdictions, even in the US. So I don't know quite how you address that in a succinct way. And I'm not a huge fan of what we started out with Zika was 5-page addendum regarding Zika, because it was mostly medical advice, and we're lawyers, not doctors. So I always seem to go back to following the basics of the contract, which say follow doctor's orders and let the doctors instruct on what the concerns, restrictions, and actions of the parties should be.
Okay. So someone asked if we had a list of the limit of stay for each country. I don't think we do. I mean, most people on ESTA visas, which is most of Europe and some other countries, I don't have the full list, but it's usually a 90-day stay. I know with China, they have to apply for a certain visa that's going to be longer, and other countries where they have to apply for visas outside of ESTA are longer. But I know that just the basic ESTA visa is 90 days, and I believe, Rich or Steve, you can tell me if I'm wrong, if they do apply for one of those extensions that we talked about earlier, I think it's a 30-day extension that they're awarded.
Yeah, it's a 30-day extension. It's referred to as a satisfactory departure extension. And right now, this was as of a couple of hours ago. Let me find that note. Hold on. The USCIS does not seem to be, it's not clear that they're going to be doing that kind of work. They've closed all of their district offices to the public. All services, including interviews, for example, are canceled until at least April 1, and they're only providing emergency services. So unless they're really up against the expiration of their visa, they're probably not going to take their call right now. But one of the other keys to this is if you are applying for an extension, you should apply during the time period in which the visa is still valid. If you apply outside of that time period where the deadlines are passed and you've already missed it, you might get further scrutiny.
And I can add, just from speaking to an immigration specialist this week, that, you know, worst case scenario, if they violate that stay and, you know, because they're waiting for the baby to get passports, or there's an issue with getting a flight out of the United States, it shouldn't, they're not going to chase them down or impact them in a way where there's a criminal penalty. It'll be a tag on their you know, passport and visa for the rest of their, or at least I think it's 10 years. I think Rich, you had mentioned, but
yeah, no,
not,
if you're deferred at the airport, like you can't get a flight because there aren't any flights anymore, and you're delayed within 14 days, that may still qualify you for an exception. So if you're just trying to get out and you're delayed, that's a different story than having to stay for 2 or 3 months or a month or whatever past your visa. And then you might be, you know, red flagged for the next time. You might not be able to go through the application process. You might have to go through some scrutiny.
This is more of a medical question, and I don't know if there's an answer for it yet, but one question was, has there been any studies if terminating the pregnancy would work as a treatment for pregnant women with the virus who are on a ventilator? Is that anything been mentioned in the journals or anything?
I mean, this is Saeed, but I'm not aware of any particular study that addresses that. It's just a matter of that pregnant patients, sometimes during flu epidemics or these types of epidemics, may be at higher risk. And again, the studies on coronavirus are limited. I think we're going to have a lot more information in the coming months, but they could be at a higher at-risk group versus, for example, a population that's non-pregnant.
There's a question, should surrogates be sheltering in place even if they work in a small office of 2 to 3 people? So should surrogates be basically home quarantining themselves if they're pregnant?
Rich, you want to handle that one, or you want me to take a stab at it?
I think it should be medical first.
I agree.
All right. Eve?
Yeah, so I mean, I think everyone should be self-quarantining, and I think that the surrogates should, I mean, pregnancy per se is not an increased risk for development of coronavirus or development of COVID-19. But I think if everyone were to self-quarantine, we would flatten the curve and we would nip this in the bud a lot sooner. So my recommendations for surrogates are exactly the same as my own recommendations that we've been following in our practice and my own recommendations that we've been following as a family.
And I completely concur with that. One of the interesting studies in the New England Journal of Medicine was that in China, 86% of those who had significant symptoms from COVID-19 infections were actually infected by asymptomatic carriers. So they looked at basically those people who were in contact with these particular patients. So a significant number of, and this, it could be tenfold, it could be hundredfold in terms of number of cases that we we think we have right now. There are many, many people out there who are asymptomatic, but who carry the virus, who shed the virus. And so to Dr. Feinberg's point, we have to have restrictions, and we have to have social distancing. We have to have measures in place in order to decrease the risk for all of us, because we really don't know, which of us is asymptomatic and carrying the virus, and who doesn't.
And I think that medical advice is spot on. And I think the government advice, whether the governor of New York or the federal government or the mayor of San Francisco, is going to go in that direction, and the surrogates should be adhering to it. From Rich and my perspective, the question we're going to get from agency owners is, can we make them if they don't want to? If they have a funeral or a wedding that is going to go on against these recommendations, is there something in the contract we can rely on to say you don't have a choice? Because oddly enough, we have surrogates that don't always follow those recommendations, and the contractual issues come up. So that is going to vary contract to contract. I suspect, having practiced for 30 years and seen scores and scores of contracts, virtually all of them, the vast majority, have some phrase somewhere that says the surrogate will not do anything that will unreasonably prejudice the pregnancy, but we haven't determined whether COVID-19 prejudices the pregnancy. What the doctors are talking about is the spread of the virus and the national interest in flattening the curve, which may have nothing to do with the pregnancy or the terms of their agreement with the intended parents. So again, that's going to be contract specific, and it's going to depend on the language. And in 30 years of practice, every night I go to bed, I say to myself, God, I've seen it all. And then I wake up the next day and I go, shit, I've never thought of that, never experienced that. And then my contract gets another paragraph longer. I guarantee you my contract is going to be looked at to address a situation like this. Rich, what are your thoughts on it?
Well, I had a question come up a week or so ago from a surrogate whose university health system in Colorado was saying that if she traveled to California for the transfer, they would make her quarantine herself for 14 days and not come into work. And the lost wages situation. So the question that raised is, would the parents pay for the lost wages? Because this was, a quarantine situation. It wasn't really addressed by the contract. So we were getting to the point where we had the parents agreeing to lost wages reimbursement, even though it wasn't provided for in the contract. And then we decided, you know what, let's not put her through the stress of worrying whether she's got this or not, and her family being stressed about her traveling. So they just delayed the cycle.
Yeah, Wendy, do you want to talk about your circumstance you had with the parents and the surrogate traveling to California?
Which one? I have several.
Yeah.
Are you talking, Rich? It's probably our case together.
Yeah, that's probably true. Might be the same case.
Yeah, I mean, I think we've kind of already addressed it. We've got cities on lockdown where everything's closed, and there's the concern for, so I don't think it's any different really than international clients trying to come here.
Yeah.
So Dr. Feinberg, quick question. Is there a date, or when will ASRM task force give another update?
March 30th. So we're going to be reconvening every 2 weeks to review the data, look at some of the curves of transmission. And the CDC has a pretty definite definition of when that curve is flattened. It goes below the inflection point of new cases. And so the goal is really not to wait until the pandemic is over before we say, go ahead, resume pregnancy attempts. It's once that curve is flattened to the point where the utilization of resources is such that it's permissible to resume non-urgent care. And so the hope is truly 2 to 4 weeks of pause and then resumption full on of patient care.
Thank you. Sarah, if you want to unmute, if you're not, I have I'm now realizing that the questions are basically coming in order of who is speaking. That's good analytical skills here. So there's a couple in a row, Sarah. Will there be any policies available that will cover COVID-19? Oh, I might have to unmute you. Are you still there, Sarah? Can you hear me? There you are.
Can you hear me?
Yep, now I can.
There you are.
All right. So that's the
Okay.
first question. Are there any policies available that will cover COVID-19?
Well, so in terms of grabbing insurance right now, anything through the Affordable Care Act would. Also, I did speak with, or I had sent Prime, which has switched over to LifeGrow, a couple questions as well. And they also stated that they would be covering anything having to do with the COVID-19 based on the way their policy is worded. The other, like I said, the universal and the new life policies, because they are maternity specific, anything having to do with the COVID-19, just by the nature of the policy, would not be covered in that capacity. So yes, there are policies. We're looking at, again, Affordable Care Act, if they open that back up for everybody. And again, there are limited states, or also through LifeGrow.
Quick question, and the answer is probably yes, but will you email or notify when others, if and when other states open up ACA enrollment?
Absolutely. Absolutely.
On the radio, it stated open enrollment is open until April 30th. Is that the case?
For California, that would be the case. Other states are mostly the ones that I listed in terms of Connecticut, and Nevada, New York, goodness gracious, Massachusetts, Maryland. They are all through the 15th, except for Connecticut is through the 2nd of April currently, and then Washington is through the 8th.
Okay. This next one is, did you say that Lloyd's is not covering death from COVID under its life insurance plans?
They aren't any accidental death policies, so it depends on how it's written, but Lloyd's is written as accidental death. So that would be correct, that if there's a death from that, they would not. And also, there are accidental death policies out there through other carriers. So if they are underneath an accidental death policy, they need to verify that. But everything that I've researched currently says that if it is accidental death, they do not cover infectious diseases. And so therefore it would not be covered, or COVID-19 would not, if there is a passing, it would not cover that passing.
You might have an answer to this, and someone else may want to jump in too, but it is about an insurance policy. So if a parent cannot get here and an agency takes placement of the child, or even probably a third-party guardian, is there a separate liability insurance plan that could be purchased to protect either the agency or the individual?
So we are currently working on that, but no, there's nothing on the market. That is a little bit of a problem, because part of professional liability is that it has to be within the scope of your business. And so if it's not within the scope of your business, then there is a potential liability issue. But obviously, in the wake of everything, we are working with the Lloyd's market to see if there's something that can be placed for basically on top of a current policy that would allow that to happen in this situation. But right now, no.
Okay.
So to the agencies, if the option for caring for a child falls to agency staff, you need to be looking at your insurance policies and talking to Sarah or some other expert to determine whether you're covered or whether you can get something. And that should enter into your decision whether to go take care of those babies.
Yep.
Dean, can I interject a quick one for Sarah?
Yes.
And this may be hard to answer, Sarah, because every policy is different, but if someone has an umbrella insurance policy, like an individual, would that cover them if there was any liability for making a mistake while caring for a child temporarily? Do you know?
Honestly, we would have to take a look at the specific policy. That potentially would, if it's an umbrella policy, and so therefore it does cover a lot of I guess, excess jurisdictions on that side. But yes, we definitely would need to take a look into that.
Okay. I'm just going to announce, so I don't know if there's a hard stop at 10:30. I'm not sure how the programming works, but we're going to try and get through as many questions as we can. If it goes beyond, if any of the panelists have to drop off or anyone on, like I said, it's recording, but I'll keep going. So does anyone know if what are the options for a state that doesn't recognize temporary guardianship? They only accept permanent guardianship approved by the court, and hospital acceptance of power or attorneys, is it only at the whim of the hospital? So I guess, is there other options outside of a temporary guardianship in states that don't have that as a legal ramification?
There may be,
Go ahead, Rich.
yeah, there may be powers of attorney that can work, healthcare powers of attorney. A lot of the hospitals may have their own forms as well, but they might prefer that you use. Obviously, speak to an attorney in the relevant state where the care is being given, so you can get the most specific and pertinent advice.
Yeah, and just so agencies are clear, and this is just kind of a structuring clarification, you have documents you can sign at the hospital with the consent of the participating parties that the hospital will respect. Those are internal hospital consents and transfers. Different hospital systems have different degrees and documentation for that. Then you have statutory or statutorily authorized transfers of parental authority, which vary in scope and effectiveness from state to state. Some of them require court approval, some of them don't. In Minnesota, it's valid for 6 months and then you need court approval. And then there are official guardianship proceedings in court, which are going to be impacted and impaired because those are probably going to be cases that are not of high priority. And if the courts are limited staff, you may not be able to get them heard. So again, that's going to be state by state. You start with the hospital, you go to the informal documents that don't need court approval. And if you can't get either one of those, your only option is going to go to court. Don't you think so, Rich?
Well, that's a possibility, yes. But there's another mechanism that could work. There was this concept of what's called a standby guardianship document. It was created in the height of the AIDS crisis, another, sort of epidemic in a way. And it was created to give someone the authority to take care of someone, make decisions, etc., without having to go to court. And it was meant to be potentially temporary because, sometimes these people would go into hospitals, they'd get better, and then, they'd get out. So there's a standby guardianship concept, which may or may not work in every jurisdiction, but it's another thing to at least look into.
Yep, and that standby guardianship in Minnesota, the difference is that it's not an immediate transfer. It's a standby guardianship that's triggered by an event that occurs, which is why it may apply in this situation, right, Rich?
Yes, exactly.
Yeah, so you just have to define the triggering event and put COVID-19 and the circumstances surrounding it as the triggering event, and that may work. So that's a great catch-all, Rich. Thanks.
Quick question. Someone who's in contracting right now representing a gestational carrier, do the legal side on the panel think they should continue with the contracting even though the medical side will be delayed? What are the thoughts?
Yes.
Yes.
That was an easy one. That was easy.
But
Question.
Here's the thing. Like many contracts I see say the surrogate agrees to up to 3 transfers in a year. If you have language like that that's temporarily focused, you need to look at that and edit it according to the circumstances and open that up so the parents aren't hackneyed by a time period that's going to be so significantly varied by the virus that it's not enough. So make sure you're paying attention to that.
Question for anyone on the panel. Has anyone attempted to have foreign nationals travel to the U.S. using the exception from the order that the parent is an immediate family member, and how did the process work? So I think Rich has touched on this a couple times already. I can say we've had multiple parents come in, some right after the ban, using the letter we sent them. One of the dads was already here, but the other dad was denied at the airport with the letter, and we just told them to keep trying. But yesterday we had today we had a parent arrive, and they showed the letter at customs and it worked. So I think the issue is, and Rich had mentioned that there is no actual, this is the process to take with these letters or this exception yet, because they're so busy with other things that they're not really defining, much like many other orders that have come from this administration, they're not really defining what they mean, and people that are making the decision on the ground are going to differ from place to place.
Yeah, exactly. There's no real defined guidance on what process to follow, who makes the decision. So it can sometimes, depend on who you get on the day you go to the airport or the customs office.
And it's going to depend on their interpretation, whether it means the child's actually already born, and you have a birth certificate, or like we were talking earlier, if you have a pre-birth order in place that's saying you're the parent. So I think this is something we should continue on our different listservs, on our surrogacy professionals page, to comment when something positive happens and how you did it. Don't keep the secrets to yourself. We're in this together.
Yeah.
Just a comment that I think it was said earlier, but don't just think about hospitals as state by state. Think of them as hospital by hospital, that each hospital is going to have different requirements as to who can come in and who can't. So you're going to have to be calling the powers that be at those hospitals. I will say what I've seen, and I've heard, there were stories posted on Surrogacy Professionals, and we've had it happen in a couple of our cases where they were adamant that only one parent or no parent could come in, but after a couple of days of talking to them and having the parents talk to them, they did allow for 2 sets of parents to be there for the birth. So I think the more in contact you are, the potential better outcomes you can get, but that's no guarantee.
Dean, do you think the person interfacing with the hospital should be the agency owner and staff, or the attorney in the jurisdiction? Which do you think is more effective?
Yeah, see, this is the hard one. I tell people that we want to do it first for them to try, but I mean, and I think probably we have this experience for the last 20 years of surrogacy, that sometimes when that parent makes the plea, it falls on, a little more empathetic person at the hospital. And, if they've done everything right and they've quarantined and they can explain how they've, remained, it might be better. I think the agency should try first just to reach out, but I don't think it hurts for a second step for the parents or the surrogate or anyone involved to do it too.
Do you have ideas of how to coach the parents to frame their comments so that agencies know how to coach them?
I just, what we've told them, and it's probably more of the coordination team than myself, but just explain to them the situation and what you're doing. And in one of the cases I can think of, and I wasn't fully involved in it, but one of the parents had actually just had surgery and had been home quarantined for over 2 weeks. So they had a story and a medical note from their doctor, et cetera, and it worked. But I mean, they can only try. If it doesn't work, yes, it's awful they don't get to be there, but they will see their child within a couple days. So I think it's that combination of coaching them what to say, but also to make them ready to understand that, it's awful. You're going to miss potentially this 24, 48 hours, but at least you're there. You're going to be with your child immediately thereafter. And there was, everyone tried their best to get it accomplished.
Yeah, I think I saw in the ABA listserv a comment from someone that said hospitals are working out arrangements when they're dropping people off that you can drive up and drop off and they can go in, and that can work in reverse to take the baby out. The intended parents can drive up and they can bring the baby out. That doesn't help during the inpatient stay of the baby if the parents can't get in. It's certainly a function of transfer at the end of the baby's inpatient stay. And it's also going to depend on whether you're in a pre-birth or a post-birth state, because in a post-birth state, those parents have no authority to get the baby. The surrogate's going to have to literally carry the baby out and hand it to the parents. So again, there are variations there state by state.
I think another thing to add to that is I was talking to someone at another agency today who had parents that were barred in, but it turned out the hospital had exceptions for allowing, ill family members in the hospital when there was an end of life situation for the patient or the situation inside the hospital. And so they made the argument that maybe that should apply to beginning of life as well, and they were able to get in. And I would just add, you cannot go in yelling at the hospital.
Oh God, no.
It'll get you nowhere. As angry as these parents might be, or frustrated or stressed, we have to caution them to be calm.
Very much so.
Let's see. Hi, Eve and Saeed. It's Nancy Block. Sorry if I ruined anonymity here. If there are surrogates that
Hi, Nancy.
that work and IPs don't want them to work right now, we tell them they should ask their doctor for best recommendations. What are you as doctors telling your patients in terms of working in a workplace right now?
Work from home.
Yeah, I think if you can work from home, I think the recommendations are for the same as for all of us. Is if any work can be done from home, work from home, and the social distancing is really the key to be able to battle this and come out at the other end.
Well, if they can't work from home, is this a statement from a doctor that says you can't work because of your condition that will trigger lost wages for the surrogate?
Well, I think at this particular point, we would just say that if you do go to work, you have to be abiding by all the recommendations of the CDC in regards to social distancing. As I said, there are a lot of asymptomatic carriers that are just without symptoms. So you have to sort of assume that we're all at risk, including surrogates. So they just have to take the extra precautions at work.
Yeah. So,
Yeah, I don't think we can write notes stating that patients are unable to work, but I think it is within the purview of a physician to recommend working from home. I mean, pregnancy is it's not a medical disease, it's not a restriction, but to really enable any such accommodations, not just for the surrogate, but for everybody to follow those simple CDC recommendations on distancing and hand washing.
I think too, I'm going to speak kind of a little bit about the insurance side of things of potentially going on short-term disability or even unemployment. I know that there are several states that have put into action if their reduction of work, either with disability, state disability, and or even partial unemployment during those times. And also that the short-term disability policies are being more lenient with what is going on with COVID-19. So there are going to be potential avenues for the gestational carriers to take to be able to recoup some of those funds, so it's not all on the intended parent per their contracts. So things to look into for the state as well as their own employer as well as their STD policies.
And I got a note here to say, make sure we wish Sarah Page a happy birthday since she's spending it all here with us tonight rather than.
Thanks,
So happy
guys.
birthday, Sarah.
This is the current version of parties.
I told the panel a little bit beforehand. I had a Zoom party at 3:30 with my friends. It was very awesome. So,
workarounds.
yeah, workaround.
And Steve, I got a text from someone when we were talking about dealing directly with the hospitals, and it was actually a good tip I didn't think of, is a lot of times our local attorneys on the ground that we work with in the different states have differing and better relationships with those hospitals because they're in there so much with pregnancies and surrogacy births that's another avenue where maybe you have the local counselor reach out first before the agency or the parents, just because they might have that secondary connection to the hospital.
I would absolutely defer to local counsel. And that's one of the things that is inherent in what we do. Each state, the visibility of the process and how it's been put together with the courts, with the hospitals, with the birth records office is going to be largely a function of the local counsel that are visible to them. So when I say should the attorney call or the agency, I'm talking about the local attorney, if the attorney should call at all, because that commenter is absolutely correct. They have a better relationship and a pre-existing relationship, and hopefully an in that outsiders don't have.
There's a comment here from Kim Surratt, who's an attorney in Nevada, who says that she has part of her firm is an estate planning firm with 2 of the top estate planning attorneys in the country, and the software they use has templates for every single state, so for different documents. So if people are in a bind, she said she's happy if they reach out to her. She can help them get the documents and still work with an attorney of record in that state. But if they need a starting point, she's happy to assist at no charge. Thank you, Kim.
Thank you, Kim.
Let's see. Hopefully we have.
And on that comment, just remember that Kim is going to connect with an attorney in the jurisdiction because the documents have to be effective in that state, and that involves local practice of law and licensing and state authority. So if you can find an attorney that's experienced in estate planning in the state where the surrogate lives, that's also experienced in art, that's optimal. If you need Kim to find that, she can help you. But those are state-specific issues and vary by statute to statute, and there may be templates, but it's best to have someone in that state working on those issues.
Sarah, for those accidental death policies already in place, can an addendum be added to cover if death by COVID, or would they need a whole new policy?
So we're actually working on that currently. Just so you guys know, one of the things that had been brought up previously was actually regarding strep throat. And if there was a complication due to the fact that a pregnant person could not take the necessary medication for strep throat, would their death be covered? And the answer was yes. So I think there's just more work that needs to be done with them in terms of the Lloyd's market to see what really we're talking about here. Because there are certain things where if they cannot take it because of the pregnancy, then it truly becomes a complication of that. The issue that we're talking about right now is that if we pull them off the policies, there's no guarantee, especially if they are pregnant, that I could get them a different policy, because a lot of insurances won't take you when you are currently pregnant. So I'm going to say at this point in time, give us 24 to 48 hours to really talk to the Lloyd's market and everybody else in the A, B, and B policies and figure out truly what we're looking at with this, because it's kind of all coming down within the last 24.
So just in case we do shut off in a minute, it's been wonderful, and thank you again to everyone, but we're just going to keep going until it shuts down. So hopefully it stays live. So we got a question about potential workarounds. So someone has a pre-birth order in place, parents are 1 state over, it's a domestic case, but the hospital just told them that parents would not be allowed at all into the hospital. Is there any legal ramification against the hospital for not allowing the actual legal parents to access their child? Both of the genetic parents, it's a pre-birth order. Any suggestions for responding to the hospital based on their potential liability?
I would use that argument to get them to change their mind. I don't know what liability there could be other than maybe emotional distress. I mean, that's a.
Are we allowed to jump in?
Yep.
Okay, this is Meryl. Hi, everybody.
Oh, I didn't know you guys even could do that, but sure.
Guess
you can.
What? I just figured that out, so I'm doing it because I just had this happen. So I think I'm going to share. The answer is there is nothing you can do. And I just dealt with this with an Ohio hospital. They would not let the parents in because they were from the state of New York and they're high risk. And I not only dealt with the hospital attorney, I dealt with the attorney for the Department of Health for the state of Ohio until 1 a.m. And I can tell you that there was no legal precedent to help anybody, and that at the end of the day, they weren't happy that the parents were yelling at everybody. So I can tell you, please don't yell at anybody. And this was a case where I had to really calm the parents down and explain this is happening everywhere. It's changing by the minute. They are literally giving them their baby in a special room with hazmat suits on, because they didn't want anything to do with these parents from New York.
The other comment on that is that, remember, the hospitals look at this from a different perspective than the lawyers. Their liability and their connectivity to the people in the building are as patients, not legal parents. And there may be, I think I agree with Merrill. I don't think there's precedent for distinguishing between a patient and a parent. So the surrogate as a patient is going to be in the hospital. The baby as a patient is going to be in the hospital. If the hospitals are restricting people to patients and restricting other people related to the patients, in other words, if a sick teenager has parents wanting to come in and they're restricting visitors, they can keep the parents out, is my guess. So just remember, there's a distinction between legal parent and patient.
Question, I'm concerned about naming surrogates, agency members, or friends and family as guardians to the level of legal responsibility. What if babies get sick? I believe guardian then becomes the named responsible party for medical expenses. Is there any way to limit the legal impact? And how do we carefully advise proposed caretakers and official guardians about their responsibilities and risks?
Well, Rich, doesn't that go to the release and indemnification that you would put in any agreement that was set up between the parties?
Yeah, I don't see any different.
I guess the one question I would have, and maybe Steve, Rich, Sarah, if it's a temporary guardian that's not a court document, can someone add the child to their policy as a dependent, or do they need a court order establishing that temporary guardianship? Or is it it's obviously going to depend probably insurance to insurance? That's a dumb
Yeah, it
question,
depends
but
on insurance to insurance,
okay.
for sure.
And of course, they won't want to cover because they're insurance company, so it doesn't matter anyway.
They cover everything. They're so great. Come on.
Yeah. Okay, someone mentioned the possibility of someone other than the parents getting a passport. Do we know how successful or difficult that is? I think Rich or Steve, that was you talking about that form F305 or something to that extent.
3053, I think it is.
3053.
There are documents that can be signed by the legal parents authorizing other people to get the passports for them on a walk-in basis if that's necessary. Rich, do you have any other comment?
Yeah, there's a couple of things here. I've actually had a situation already and have another one coming, actually unrelated to coronavirus, where the parent will not be able to be here. And there are circumstances in which a power of attorney, along with the DS 3053, can be put together and to allow the person taking care of the child to apply for the passport. You'll have to have, a lot of other proper documentation to submit with it, but there is a process for it. It's not something that the State Department sees frequently, so it may be subject to further scrutiny. We certainly have, extenuating circumstances that we could use to sort of defend the reason for that application, but I think it would pass. And I want to also just say there may be situations where we can't get the birth certificate if the vital records offices are closed. I don't think that's going to be a huge issue. Most vital records offices are saying if you submit a fax or email or mail request, they'll still process the birth certificates. But let's just say hypothetically you don't have it. That's a key document for the passport application. There is a form called the DS-10. It's a birth affidavit. It's typically meant as a document to sort of verify that you've known this person. If you don't have a birth certificate, to go along with your passport application, someone can verify that they've known you for a long period of time. But it could be used in this scenario when you don't have a birth certificate. You would have the hospital's birth certificate, the souvenir version, hospital birth records, and supplement as much as you can with as much as you can think of creatively with the birth affidavit, and you may be able to get the passport even without the birth certificate.
So here is a specific situation. I think I know what the answers are going to be, but Rich, the thing you had touched on earlier about FMLA might come into this in the new law that just passed, but pregnant surrogate 7 months works as a nurse at a walk-in clinic in Washington State. IPs would prefer she doesn't work, but she's worried about job security and does not qualify for LFMA unless she's actually sick. Any advice how to address?
Yeah, I think the new Families First Coronavirus Response Act would apply. It does not require that you have a doctor's note that you're sick. If the quarantine situation is in effect here, then she could probably apply for FMLA under this Response Act. It would give her 2 weeks of paid, fully paid salary up to a certain cap, and then 12 weeks of up to 67% of her salary up to a cap. So I think in that scenario, she could get a lot of her lost wages covered, and the parents would cover the difference.
And she seems to be in a high risk because the follow-up on it was the surrogate said precautions are in place to keep her away from respiratory cases, but in her area, all testing is being done at the clinic and not the ER.
Yeah.
Is there any way to legally ensure a surrogate is not forced to give birth without at least one support person present? Chiming in here, as a surrogate quarter as well as a pregnant surrogate due in the next 3 weeks, the prospect of a surrogate having only hospital staff for support is quite scary, and I've been seeing some posts about this.
I would suspect that they're going to have to follow hospital policy, period. I don't see much they can do about that. If public health measures are such that they think that it's necessary to restrict anyone from the delivery room other than medical personnel, then I don't know what leeway you're going to have.
There is a question, how are attorneys suggesting handling lost wages for surrogates who may be in higher risk fields?
Well, most of the lost wages depend on a physician's affidavit indicating an inability to work. Rich, do you have other contractual provisions that may apply?
No, I would agree. Most of the contracts would require a doctor's note that you can't have restricted activities. But I do think, again, this Coronavirus Response Act would provide some FMLA relief.
And I think everyone in these situations, particularly if you're not attorneys and your agency owners that are coordinators that are outside of the legal field, just get the two attorneys involved, because there may be situations where the intended parents are okay with paying lost wages for extra time because they want their surrogate home, and if her, it's not going to impact her job and she wants to do it. I think getting everyone on the same page and getting the attorneys involved to read how the contract's written and potentially, add addendums where need be, and everyone might be okay with it. So it's worth revisiting in certain situations.
Yeah, the GCAs are drafted. If there are things that come up, remember, they can always be amended, added to, or reconfigured to fit the circumstances. And all it takes is consensus between the parties. And the agencies can start setting that up in the way they discuss the issue with their respective parties so that they're open and amenable to agreement. So the agencies have some power here, but then they have to turn it over to the attorneys to document it.
This question is for Sarah. It's, I wish I could text it to you so you could see it because it's a long one, but all right, so clarification question. Lloyd's policies for maternity are not currently covering testing or treatment due to the infectious disease exclusion. The question is, what if the surrogate is in an area where testing is not widely available but experiencing flu-like COVID symptoms? How are claims teams determining coverage if she hasn't tested positive, but they treated or hospitalized her out of an abundance of caution because of the pregnancy alone?
Now, I think, again, the first thing to understand about the Lloyd's policies is that they are maternity only. So even if it's a flu test, if there is nothing that is maternity related in that capacity, then it wouldn't be covered anyways. They would get a discount, they would adjudicate it. But again, these are maternity only policies. So just keeping that in mind.
Okay. And then there would, would it be potentially an argument that if they admitted and treated beyond because of pregnancy, there may be coverage? Is that the
Yeah, absolutely. At that point in time, if there's maternity coding within it, if they're calling it a complication of pregnancy, then yes. Then at that point in time, that's if they did deny for any reason, then you could easily file a grievance and ultimately would hope that there would be coverage for that.
Okay, let's see what else we.
Dean, can I interject a question?
Yep.
For Allison. I know the CDC has a page on their coronavirus website that talks about managing stress during this time. Do you have some key tips and points for people to think about, all of the professionals on here, plus all of our clients and patients?
You bet. What I think the first thing is for people to kind of find structure in their day, as I believe Rich had mentioned, and just having some sort of routine and finding a new normal in this time period. I think it's helpful for each person, like we'd mentioned before, at 4 or 5 in the afternoon, you go take a walk and have that there. I do think connecting with loved ones and communities, professional communities like myself, is very helpful, because then you realize, oh, I'm not alone. It's not just me. That can be helpful. I read something yesterday that I thought was very poignant, in that it's how we're looking at this. And it's real tempting to say, oh gosh, I'm stuck at home and it's just, it's going to be a long time. It's going to be the summer. I may have my kids with me or not, or I'm missing work or not. But if we really reframe it and look at, yeah, that might be true, but it's also a time to work on things you've wanted to get to, or work on yourself, or issues, or personal growth, because this is the opportunity for that. I think that's very helpful. Obviously, if you can still exercise, I know gyms are closed here in Colorado, but getting out and walking, running, if you're able to, meditation is very, very helpful for those that are, let's say, have restrictions on exercising. I think it's important to stick to your routine. Just because you might be working from home or feeling like this is just a free space, it's still important to go to bed when you typically go to bed and wake up when you do, so that when this is over, your transition back into your workspace isn't as difficult. And then obviously connecting with others through video platform. I'm also, wanting to remind everyone, there is a big group of mental health professionals that are part of ASRM that are readily available. And that is for intended parents, surrogates, anyone, but don't feel like you can't reach out to mental health professionals. They're doing everything they can to help anyone and everyone.
Some comments of what was going on. I mean, one question, I think it was when we were talking about the letter and how to get here, there was a comment that for USCIS purposes, having that affidavit, Rich and Steve, I think that you mentioned from the doctor saying who the genetic parent is, might even be stronger than a pre-birth order, just so, because they tend to care more about genetics than anything, as we've seen in a couple of those bad cases of American dads not getting citizenship to their kids born overseas. A quick comment that as of today, Malaysia and Dubai are 2 countries that have shut down for Chinese parents to quarantine pending coming to the US. So if your parents were thinking about this, those are 2 countries that are no longer available for temporary stay. A comment that the ASRM mental health professional group is working on a document which will make recommendations coming out very soon. So stay tuned. A question for Eve: at what level of the curve do you think ASRM would be willing to lift the recommendations to halt procedures, if that's even been discussed?
That's for Eve, right?
I think she just had to pop off.
Oh, okay.
I think I can jump in because I had a discussion with Eve about this. I think it has to do with the number of new cases that come in. So if you see a flattening of the number of new cases, meaning that the number of new cases will remain constant or in decline, then that's a point at which we've reached a flat point of the curve. But what's happening right now is the number of new cases. For example, what's happened in Italy for the last week to 10 days is the number of new cases has just been rising exponentially. It's been doubling about between every 3 to 6 days. We'll know when we hit the flat part of the curve is when the number of new cases just remains constant or starts decreasing.
And we got to remember too that they really haven't been testing here, so it might cause more panic because there'll be lots of new cases in the near future, but a lot of them may be these type of sadly, if you're an NBA player, it's easy to get a test done regardless of whether you have symptoms or not. But you're seeing a lot of asymptomatic people test positive, which is good and bad. There'll be more people that have it, but it'll also show that it might, it's hitting certain communities worse than others.
There's one other factor as well that is sort of the physicians or the experts' nightmare, and that is sort of that double hump phenomenon, where as China comes out of its thaw and people start going back to work, and sort of the factories come back to life, there is that possibility because there's no herd immunity. It's a term that epidemiologists use, is the herd immunity. Then the virus can make a comeback. This has happened with influenza before. This even happened for example, even with the Black Plague in the 1400s, where it sort of made several mini comebacks in later centuries. So that's a worry, is that if we don't have herd immunity because not enough people have developed immunity, that there could be that second rise in the number of cases. China would be the first to show it.
This is a medical question. It might not be specific to COVID, but if a child is born here and has not had any vaccination, is there a recommendation whether the child should travel overseas or not?
No vaccine in terms of like a flu vaccine or any.
It's a general one, so I'm guessing any vaccinations at birth.
I mean, if they're born here in the United States, they're going to have the typical vaccines that the children have. In regards to the COVID-19 vaccine, the first group of patients, the first 45 patients, started having vaccinations as of today and yesterday. But we won't know for about a year until whether the vaccinations will work.
Let's see. The question is, should we expect more clinics to begin stopping or delaying cycles? Right now, it seems many are business as usual.
I think I guess I can take the medical question, is that ASRM makes recommendations and provides guidelines, but they're not a sort of a policing body. There are already many fertility centers, actually some of them very large ones, that provide a lot of care in different parts of the country, that have already said they're not going to stop operations. They're going to continue, but they're going to take extra precautions, extra measures, and they've actually have criticized the decision of ASRM in terms of stopping cycles. So there are going to be many centers out there. They're going to continue. But I do think that a pause, at least in the transfers, is a really good idea because of the risks we talked about in regards to pregnancy.
Two questions that are very similar in nature for the legal side. Scenario one, if a surrogate decides to self-quarantine, would she be entitled to lost wages? And then scenario two, if a surrogate has stopped working due to COVID-19, either from illness from herself or for fear of illness, from a contract standpoint, would she be entitled to lost wages?
I'm gonna let you go first, Rich. I want to hear.
Yeah, I mean, I think we've already hit this topic before.
Yeah.
I mean, I think if she feels like she needs to quarantine, that's her choice. If the parents agree, I mean, it makes sense, for health and safety, but it's probably not covered by the contract. So work together and, do the best they can. I mean, if this new Coronavirus Response Act gives parents the ability to say, okay, yes, and I won't have to pay all of those lost wages if you can get that new, Response Act coverage. Now, I have no idea what red tape will be involved in getting those wages paid through this new act. And I'm sure it's going to be a bunch of red tape and it's going to take months to figure out. So there's that.
Yeah, so that's just another admonition to negotiate any holes that exist in the existing contracts because this wasn't anticipated. And that's where you have to bring the parties together, depending on the preferences of the parents and the fears and preferences of the surrogate. But if you get hard up against the contract, Rich is right, it's probably not going to be justified.
The next question is something that we haven't touched on, which is, what if there is no one to be the guardian of the child? What is the possibility? Is foster care available, or what would happen from a state perspective?
So I actually have this happening right now. I've got a couple from Spain that's been barred from traveling, and they, because I've got great staff here, they've been helping figure this out and working with the agency. They've found a foster family to help take care of their baby during these weeks when they're barred from coming. An amazing family that stepped up. They've been foster families to other children. So that's an avenue to look into. I don't know much about that area of family law because I've never done it, but they've talked to these people. They've had criminal background checks run just to be safe, and they're good to go now. So I think that's an option.
Is that through the formal foster system, or is it a set of foster parents that agreed to accept children outside the system?
In this particular case, it's outside the system.
Right. So I don't know if all states have drop babies on the steps provisions and they go into foster care, but I don't think you'd want to put them in the formal foster care system, because then there are all kinds of statutory guidelines and protections and transfer of authority rules that may be difficult.
Yeah, I agree.
Do we know if there's like a, secondary to this question, if there is a, national foster system, placed as a potential, alongside the list that they've put together on the surrogacy professionals page? Is that, is there something out there, or an entity out there that can be reached out to in these cases?
I don't know of any, Rich.
I don't either. I imagine that's state by state, county by county.
Yeah, right. Let's see. There was a comment that people should note that some states may relax requirements around in-person notarization versus electronic due to what's going on now. There was some Australian news that Qantas and Jetstar are now grounding all international flights by March 30th. I was made aware of this today because we had parents who had flights booked for April that switched to today because Qantas was grounding all flights post March 30th. Let's see.
I want to add a general comment. This may not apply to every attorney, but in the LGBT field, we've had to deal with not having full protections up until recently, and still now in other areas beyond marriage. But I think the lessons learned were to not give up, to focus on the rights of the people involved, the children involved, and if there's any sort of federal recognition that doesn't exist on the state level, just turn to that and say, well, look, the federal government says this, you should be doing the same. We've got this unique situation, now let's do the right thing. So if you know any LGBT family lawyers in particular, they may have some tips for you as well.
Okay. I think we touched on this, and I don't know if there's anything else, Rich, but can we discuss the benefits to the GCs based on the new Coronavirus Response Act, which I think you hit on the one section that would probably apply, which is that FMLA section. I don't know if there's anything else in the act that would help GCs.
There's nothing else that I'm aware of. I'm happy to send out something or post something on this if that would be helpful.
There's a question if clinics are moving forward with transfers and surrogates and intended parents are aware of the ASRM guidelines and have been counseled by doctors and still want to move forward with a scheduled transfer, is there any liability to the agency to letting the parties move forward?
Wouldn't that be the medical advice between the parents, the doctors, and the surrogates? I don't think whether a transfer goes forward is an agency purview. What do you think, Rich?
Yeah, I don't have any disagreement with that. Yeah, I mean, if everybody's proceeding forward on informed consent and assuming the risks, then I think the agency would be fine. But it can't be their decision, really. It has to be the parties.
There are informed consents that have been generated because of COVID-19, looking at, describing potential risks to the surrogate and possibly the fetus or the newborn, and some clinics are using that, prior to performing a transfer.
The next question was, if a surrogate's husband or any member of her household is in a high-risk category, either they're an ER doctor or something to that effect, is there any way to limit contact between GC and family to keep her safe? Assumption is the answer is no, but was asked this question today.
Yeah, I would assume no.
I would actually like, Rich and Steve, can you draft me a contract where I can stay away from my children for the next 8 weeks while they're home?
I'm sure I could create a document that would bind you in all sorts of ways, Dean.
I think somebody was saying today whether the psychosis that she was going to endure with all her children at home was a greater risk versus COVID-19 if she ventures outside.
I have my doubts.
Yeah, I'm going to throw a question out there. So, Allison,
Yes.
the COVID-19 hysteria, fear, stress, not good for a pregnancy. So if a surrogate says, I need counseling to get through this stressful period, and the contract says that necessary counseling is paid for the IPs, do you think that's covered?
I do, because there's such a mind-body connection. And, when I meet with surrogates on their monthly check-in, I'm talking about the pregnancy, yes, but I'm also talking about her life as an individual, as a whole person. I think it would be acceptable.
I just wanted to add something medically that may shed a little bit of a sort of a bright light onto this. There's just a recent study that came out today. And what they looked at is they looked at multiple different cities in China with different temperatures and different relative humidities. And what they found was that the level of transmission of the virus dropped significantly when the temperature and the relative humidity rose. So maybe that could be a little bit of a sort of optimistic factor that as we get into the warmer months, the transmission rates of this particular virus may decrease. That's something that just came out, looking at about 40 different cities and rates of transmission in 40 different cities in China.
Question for Sarah. Is there any holds right now on buying the ADD or any life insurance policies for surrogates at the moment?
Currently, there are no holds. They just need to be aware what's in the policies. So with the AD&D, obviously, if anything changes, we'll let them know. With the life insurance, word on the street with the market is that it's not, in terms of term life, there's nothing that's going to be changing. They just need to answer the questions honestly.
Question about all those cases where hospitals aren't letting people in. The question was asked, has anyone tried or considered going directly to the OB doctor rather than the hospital staff to get the parents into the hospital at birth?
I don't think the OBs can tell the hospital who comes in unless it's a patient.
Yeah, I think I read a report that hospitals are implementing their own measures, and the hospital rules will apply, not the physician who's taking care of the patient.
Let's see. There's a comment, but I'll go through it. It's from Robert Trenzio. Releases and similar documents are most likely to hold up in court if this is probably about those questions about liability. If they use specific, clear, and unambiguous languages, releases for specific event are more likely to survive legal scrutiny than releases for a more long-term activity. Some courts have rejected documents that don't explain the nature of the activity, including its difficulty, dangers, location, and other details. Some jurisdictions require special words. If we rely on a pre-COVID-19 GSA for protection, it will probably fail to defend the surrogate. So just making sure you're working with lawyers in the states where you're trying to get these releases of liability, as well as using proper documentation and specifically explaining the issues we're facing. I think we've kind of gone over it and there's really no answer, but I'll ask it. Rich, can you explain at what point in pregnancy international IPs from a travel restricted country can come to the US with one of those letters and pre-birth order? Does the baby have to be born birth imminent or neither? Should they show a copy of the certified PBO?
Yeah, I think we've hit on that already. I think,
Yeah.
if you attach whatever documentation you have, you hope for the best. And if you have a pre-birth order, but the baby hasn't been born yet, then you could add the doctor's affidavit, for instance.
Let's see. All right, question. They made mention of the Families First Coronavirus Response Act. Allows GC to apply for FMLA under these circumstances. Is this an option for all states or certain states? And secondary, is this an option at any time, any point in time during contracts, regardless if they are currently pregnant? Thank you and happy birthday, Sarah. Hey, that's so nice.
Well, the idea is this is federal legislation, so it would apply theoretically in every state. It applies to employers of 500 employees or less. There are some exceptions for employees that have 50 or less. They could apply for an exemption from this bill, for instance. But it's pretty broad. It's meant to cover most, small to medium-sized employers around the country. And I do have to say, as I'm reading through this a little further, it looks like the 2 weeks of paid sick leave at 100% up to a cap applies to anyone told to quarantine, showing symptoms, exposed to the virus, or trying to get a test or preventative care. It's a very broad definition. So
there's only 3 questions or comments left. So for Saeed, the double hump concern that people in China, is it that they get reinfected, or that people who did not get it before now catch it, or is it simply just once they release, it's still there and people get the secondary piece of it?
It's still there, and patient, the virus is still there among asymptomatic carriers. So the virus is, spread enough in the population that there are many people who are giving it to others. So the incubation period is roughly around 14 days. So people are going to shed virus for roughly around 14 days, but they're going to be new people who are asymptomatic and then will potentially go into a workplace, into a larger gathering, and give it to those who are at higher risk, because we don't know why some people get really sick from it and others are just asymptomatic. Even we know that obviously the older population is at higher risk. 80% of the deaths in the United States have been in people above the age of 60. But you still have young patients who succumb to the virus, and we don't know exactly what sort of clinical characteristics they have. It could be that their immune system has a more vigorous response, against the virus. So the concern is that the virus is still being shed, and now when people go into a larger area, larger gathering, that it's going to be spread to those who are more vulnerable.
There's a comment, the question about liability when there's a transfer going on, even under ASRM guidelines, that potentially the agency may be liable as a third-party beneficiary to a cycle moving forward. There may be potential liability there.
Well, I'm not sure. I'd love to know what the basis of that is, but I'd find it a stretch.
Yeah, I wouldn't say the agency is a third-party beneficiary. They don't get paid because of the transfer. I mean, typically, well, I guess some agencies might stagger their retainer fees. So
I mean,
maybe,
yeah.
but it'd be a stretch. It'd be a real stretch.
I mean, I would say the liability falls on the physician, on the doctor who performs the transfer, because they're the ones who are providing the guidelines and the recommendations.
Right.
Question, in the cases we've discussed where potentially no intended parent is allowed in the hospital, who is allowed to make medical decisions if there's a PBO in place and it's been provided to the hospital naming the parents as the sole parents with all medical decision rights?
Well, it would seem to me that the person the hospital is going to look to is the physical patient in charge in the hospital. If there's a PBO and the parents aren't there, the question is, are they going to telephonically communicate with the parents? Are they going to ask the surrogate as the person in the hospital who can communicate telephonically with the parents? But at some point, if there's a pre-birth order or another document transferring authority to someone else, the hospital has to be listening to that person, even if they're not allowed in the hospital. Don't you agree, Rich?
Yeah, absolutely. We have this situation come up from time to time, in a non-corona situation where parents just didn't get here in time. Baby was early. So they can communicate via email or phone with the parents and get decisions made. And really the only time they can't communicate is when the parents are on a plane. So that part's not so hard.
Secondary to that, and I think the answer is going to be yes, they should both have independent counsel, but in the guardianship situations, is there going to be need in the agreement and release, should both parties have counsel representing one the guardian family and one the intended parents?
Technically speaking, yeah, that would be better if possible, but desperate times call for desperate measures. If you got to throw something together overnight, like I had to do twice last night, the appointed guardian is a close family friend of the parent who can't get here, and they just signed it. If the guardian doesn't sign it, it's the parent that signs it. Typically, these guardianship documents are just one way. You don't have both sides signing. You just get it from the parents who want to designate their backup guardian.
There are people who advocate for different rules in our area of practice, but the rules of professional responsibility for attorneys say a party can go unrepresented as long as they're advised of the right to counsel, which I assume will govern most of these cases. And if both parties are asking the party to act, it'll be a conflict of interest issue under the rules, but in many cases where their interests are in concert and they both agree to whatever potential conflict exists, they can have the same party represent them. It depends on who the attorneys represented previously in the matter, but generally speaking, there are all kinds of waivers and consent forms as long as they're all properly informed that can allow one attorney to do it or one party to be unrepresented. Is it a technical preference in a perfect universe that they have separate counsel? Yes. Is that going to happen in most cases? I don't think Rick and I have practically experienced that. You just got to go by the seat of your pants.
And the last comment was simply that question about having the OB help, that in their case, the OB is trying to help, and it's obviously not working in that case at the moment, but the OB, it doesn't hurt to get the OB involved. So thank you, everyone. And we did go over 10:30, and it didn't cut us off. It's actually 11:11, which means we all should make a wish right now. This is either all going to go away or all of our cases are going to be handled wonderfully. I want to thank everyone who's stayed on this whole time, especially the panel who really, like I said, it came together in a flash, and everyone was more than willing to jump on pre-calls as well as this call. Everyone's provided wonderful advice. I know, as I said, in all of our listservs, in our different Facebook groups, and all these different communities, keep everyone informed of what's going on in your states, what's helping, what's not, what's international couples, all these things. The more we can get together, the better. We'll meet offline and try and do another one of these as we move forward, because I'm sure as things change every 12 hours, they will continue to change. But again, you all are, thank you so much for your questions. Thank you for these wonderful answers. Thank you all for your time. Maybe we'll try and do it with video next time as well.
Oh, I don't know, maybe not. Thank you.
Good night.
Good night.
Good night, everybody.
Thanks, everybody.
Happy birthday again to you, Sarah. Thanks for sitting in.
Happy birthday, Sarah.
Yeah, happy birthday, guys. Thanks.
Stay safe and healthy, everybody.
Have a good
Good night.
All right, good night, everyone.